as part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely green community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Thank you for joining us on the program today. And the program is Voice, coming to you from Ben Television. Voice is a program that is dedicated to giving information to our community, and this is our legal community program coming to you from Ben Television. My guest, as usual, is in-house solicitor here, Jennifer Obaseki. Jennifer Obaseki, he's the senior partner at Obaseki Solicitors here in London. It's a pleasure to have you join us on the program again. On YouTube, Google Tunde Alabi'S Voice with Jennifer, or Google Jennifer Obaseki on YouTube, and then it's going to come up with all issues you have raised, discussed, dealt with on this community program, and it's indeed a pleasure one more time to have you join us today. Again, today we'll be taking a look at two important issues for so many of you who have been following trend across the world. Of course, President Donald Trump's ban on so-called Muslims or certain individuals from certain 7 countries did seem to have spread across the world. That is, we're not saying that is happening in the United Kingdom, but underneath, if you take a look at what's happening in the United Kingdom, you find out that people now in the UK who have not been able to successfully regularize themselves, undocumented individuals, if for whatever reasons you fall foul of basic immigration rule in the United Kingdom, chances are that you may be detained, and before you know it, you are removed from the United Kingdom. So on the program today, we'll be taking a look at how do you avoid being detained and removed in the United Kingdom. That's one part, and on the other part, we'll be taking a look at Court of Appeal decisions that did not actually grant the right to stay in the United Kingdom for a parent with a 7-year-old child. You remember some time ago we discussed the soprano rule, the 7-year rule, but again, it is no longer automatic following this Court of Appeal ruling. If you have a 7-year-old child or even older, that does not guarantee that automatically you're going to have a right to remain in the United Kingdom. A Court of Appeal has actually stated these, and these are issues we'll be taking a look at on the program today. You are welcome to the program. My name is Tunde Alabi. I bring to you my guest, Jennifer Obaseki. Jennifer, senior partner, Obaseki Solicitors here in UK. Jennifer, good evening, and thank you for being part of the program today.
Thank you for having me.
Things are happening from the moment Donald Trump shot into power. The idea of our country first seems to be holding ground quite a lot. In the UK, we've had reports of people being detained, and before you could say Jack Robinson, they've been removed. What is going on?
Well, we forewarned that there's going to be a lot more rapid and, let's say, forceful enforcement action by the Secretary of State. And we've been saying this for over a year on the programme. And what we also stressed was the fact that it's going to become much more difficult to make appeals. We also the fact that there were so many changes, and that these changes meant that there's going to be a different regime on ground. And though we talk about Donald Trump, as we've repeatedly said on this programme, Theresa May used to be the head of the Home Office. She's now the head of the country. So what do you really expect? What you can see happening when I say it's come to play is all these plans with regards to making sure that immigration enforcement is more robust, making sure that it's much more difficult for undocumented people to live, to work in the United Kingdom, and making sure it's easier for them to be removed once they are detained. It's all coming to fruition. When I say that, people who are going to sign, once you know you're in that regime of being monitored, if you know you do not have a pending application and you know you do not have any pending appeal, then you know that at any time you can be detained. Even if you have an application in the system, the mere fact that you are on temporary admission into the United Kingdom doesn't mean that it prevents you from being detained. Just because you have children doesn't mean you are prevented from being detained either. So what they have done is basically retrained a lot of enforcement officers, made sure that the removal process is a lot more swift. They've also made other national embassies sign undertakings with them so that there's an understanding that the enforcement of UK immigration law will be swift, that the nationals of those countries that undocumented people will be being removed to can take place as quickly as within 5 days, within 48 hours after being detained. So far as there's no barrier to removal, that means the documents are in place, there's confirmation of their identity. And when I say documents, that could be passport or travel certificate. We discussed this last week. It means that that individual can be put in or given notification on which airport they're going to be landing in within 48 hours. Just because you're in detention and you put in an application, and we see that a lot. So people will be detained and say, oh, please put in an application for me. And because of the cost of putting in an application, people need to be very much so aware that that won't stop a removal. Don't think that just because you get detained today, you call your solicitor that same day, please quickly put in an application for me. If your solicitor's able to get the money, your passport picture, the grounds on which to put in your application, and manages to send one off, even special delivery the next day, so that's 48 hours, you know, you've got an application in there, you've got your net reference number, it does not mean that the removal directions that you're subject to will be cancelled. Even the basis upon the application on which the application was made will be looked at as best as possible. It will be looked at as best as possible. But if it's determined, and you make representations to those who are dealing with your removal, if it's determined by those individuals, those caseworkers, that your application is very much so unlikely to succeed, then unless you then go the step of getting an injunction, which is granted, you will still be removed. So you see people throwing money into applications, and that's not the way that, you know, you then have to also throw money into the injunction. And believe me, if you're actually putting this money forward, you have to realize that you should not be doing so if there is no merit in your application and there's no merit in the injunction. You can make very succinct representations to the caseworkers and not put money into an application. So if the Home Office have made an error, as we always say, if they've made an error on your case, they've not looked at the fact that you have children, they've not looked at the fact that they're separating a family unit, they have failed to address the fact that you fall or qualify under a specific rule, you must make those representations, but don't leave it too late. Don't leave it too late. Even if you're going to sign with a child, if they feel that you're going to be subject or you are liable to be detained, they will call social services to take the child and detain you. So don't think that going along with your baby or a young child is going to stop you from being detained. And it happens all the time. It happens all the time. It's nothing new. The reason why we're trying to stress this is because over the last 2 weeks, there's been a lot of, let me say, reports and statements floating around social media. Oh, the government is targeting Commonwealth nationals, this, that, and the other. Whereas the government is not targeting any specific group of people apart from all undocumented people and all illegal migrants. They basically have put in place the legislative provisions. They're now putting into place the actual, let's say, working systems to remove people more effectively. And last week, again, one of the reasons why these rumours were floating around is there was 2 chartered flights to Nigeria, which meant that in the Nigerian community, a lot of these false information was floating around, unfortunately. And it's not that anybody's targeting Commonwealth nationals. There is a general policy by the government to target people who have overstayed and who are here without documentation. And there is very, if you leave it to when you get detained to try and tackle your situation, you will not have enough money and you may not have enough time. So the things to do, which is what most people really need to hear, rather than they know that they can be detained. So it's really what happens if I do get detained? What rights do I have? Can the government just give me assistance? Now, most reporting centres have first of all decided to put up a banner to outline that people can get help if they decide to go voluntarily. The one thing that a lot of clients don't want to hear is think about going voluntarily. Why they don't want to hear it is like, Otio, I'm going to stay here no matter what. And when you say things like that, you actually don't take control of your situation. We don't want in our community for the situation to control them. We want the people in our community to remain in control of their situation. So when you see that poster, if you feel that you would benefit from getting assistance in going back home, get advice. See whether it's going to be worth your while. If it's not going to be worth your while, consider your situation. Are you in a situation where you should be putting in an application? And if you are, make sure you do so. See if you qualify for the fee waiver. But do not keep going to sign without having something, especially an application in the system that you can then lean on. One of the other problems we have is people who have applications in the system, including asylum applications, are being detained and then their refusal served on them when they're in detention, or being told that the refusal has been served at a previous address and they didn't receive it. So you only get notification of a decision when there's proof that it was given to you. So if it went to your solicitor's office and your solicitor closed or your solicitor didn't give you, and then when you're in detention you are presented with a refusal letter that you didn't know you had been, served. Obviously, you can make the necessary complaints if the person was a professional qualified and registered with a professional body. But if the solicitor has disappeared or whatever, you have to make those representations to the Home Office that I didn't receive it. This is the first time I'm receiving it. Time should run from now with relation to my rights of appeal, my rights of representation. If I don't have a right of appeal with regards to pre-action protocol, if I need to write a letter before action because my in-country or my rights of appeal are being told I don't have them, etc. So you need to make those representations and they need to be done succinctly. At this level, you don't want to be going to somebody who is not completely 100% experienced in dealing with this situation. Otherwise, you're wasting time. And also you're wasting money. But my point is, at that stage, if something unfair like that has happened to you, then you have good grounds to try and argue. At the same time, trying to make sure you have an application behind you, you also have to think about whether you are in the right lane. When I say that is, if you've been pursuing asylum, and you've not got it or you've been refused, and you've been here for over 10 years and you've got maybe children, you maybe need to start thinking about putting in a family life application. That means you have to raise the money. Again, if you've been refused under the 7-year rule and your child is now 10, you have to find that money for naturalisation, especially if you're going to sign. With families, that many of them are getting served questionnaires. The first questionnaire outlines whether you're still here, you've got a family, how many of you are in the family. Then there's a second questionnaire that comes out that outlines what are the needs of your family with regards to being removed. Again, if you are in receipt of those questionnaires and you have children that are suffering with ill health, there's mental ill health in the family, disability in the family, or you feel that you've had an outstanding application that hasn't been dealt with properly by the Home Office, there are some things you should do. You should ask for a copy of your Home Office file. You shouldn't be filling out forms if you don't know what the correct answer is. If, for example, you have a child that has special needs and you need to get the report from Special Educational Needs Officer, or you need to get doctor's reports, reply and outline that you need time to get all this information and you even need expert help to help fill the form. Because when you are outlining those issues, they may be detailed barriers to your children and your family reintegrating in your country. And therefore, it's very important that you get the necessary expert advice. But again, in relation to the detention, when you do go into detention, you should be entitled to access your lawyer. So it depends on the number of people in the detention centre as to how you may be able to access the fax machine, emails, etc. It's very difficult, as I get to understand from my clients. So you must have a phone. They don't like camera phones in detention because obviously people recording things that are going on. But it's important that you also are able to access medical help in detention. We know that being in such a place can be very depressing, stressful for individuals. So if you know that somebody, or you yourself, if you're in detention and you're not well, you must insist on seeing the medical person that's there. Again, having the visits logged, outlining what's wrong with you, making sure it's all recorded well is important. If you don't have money, you don't have friends, you don't have relatives, you may still apply for bail. The next step once you are in detention is to really see how, if you've not made an application to get out, if you're not able to make representations on leaving voluntarily before a decision is made to remove you, you should think about making a bail application. If you've managed to put an application in, it's been received. If your removal directions have been cancelled, it means there's no immediate step to remove you under removal directions. There's no flight that has been put on a specific day with you noted on it, and you have no travel documents arranged for you to leave on that flight, then you should put in a bail application confidently, which means you should be looking for sureties, and you should also be looking for a bail address. Even if you don't have sureties, that's not a reason to keep you locked up. So be confident that if you have a good immigration history where you can show that you have been reporting, you have been compliant, that you should be a bit confident to say, do you know what, I've been actually doing everything immigration has told me to do. When they told me to go and report, I go and report. I've always updated my address. I've always tried to make an application. I've always tried to stay within, whatever requirements and conditions have been put on me. Then you can show that as a good example as to why you'd be compliant if you are again granted temporary release into the community. So be confident in trying to make bail applications. If a bail application is refused, unfortunately there is a minimum timeline before you can make a secondary bail application. So it's to prevent people from just throwing in bail applications without getting their paperwork right. Don't think it's just Commonwealth nationals. There's a five-fold increase of the detention of EU nationals that are subject to removal. So as I said, this is a
EU
general,
national.
Even EU nationals that have either been wanted in their own countries, or EEA dependent family members who again have fallen foul. Maybe they've overstayed, they've not been able to extend their stay, not been able to secure their retained rights of residence, that are getting detained and actively being removed.
The question now is, people watching the program, they say, look, how do I put in an application on probably just 3-4 years old on what kind? Very many people are aware that the laws have changed, the long residency rule has
20
changed
years.
20 years now. They probably have a child who is 3 or 4 years old, and so
the fact
the
is,
heart of asking them to put in an application becomes very complex. On what condition, what basis,
you should
what
not be putting in an application if there's no application for you. Be real about it. Am I going to take your money to put in an application that you do not qualify for just because you want to put something there? When I do that, what will that do? The Home Office will tell you, come and do your biometric. By the way, you are here unlawfully, come and start signing. And then at the same time, you've alerted yourself to the authorities. If you're in that situation, rather than spend what will be your £800, your £500, or 811, so £1,311 plus your legal fees, which are not likely to be cheap, unless you go to a quack that misleads you and tells you that you have a basis to make an application. But if you go to a legitimate lawyer that's going to charge you, if they're over 2 to 3 years qualified in that area, that's going to charge you maybe £150 an hour or so. So estimated, if they're going to do an average application for you, they're not going to spend 1 hour, 2 hour, 3 hours. They're going to spend a good number of hours making the application and chasing the Home Office after making it. Why spend all that money on something you don't qualify for? I know some people will say, oh, that's easy for her to say, she's, you know, Nauma Britiko, she lives in the country or whatever. But the point is, it would be ethically wrong for somebody to advise you to make an application for something you don't qualify for, number one. But number two, really and truly, if it's you, your wife and your child, and that's 1,311 times meta, 3, you're going to use all that money to apply for something that you don't qualify for. No, if there's another way, if you're in fear of going back to your country because of maybe they're going to carry out an act that is going to cause you serious harm,
like an FGM on your daughter,
FGM
or
on a female child, harmful traditional practices even on you, there's any other reason that makes you fall into the grounds of human rights, Article 2, risk to your life, degrading treatment, Article 3, then you may have to claim asylum. That means you going to the Home Office, outlining your case, and making sure that you are subject to an interview that outlines whether you meet the threshold for asylum. Now, given the appeal situation, remember that if you make asylum application and you are on your own, because Nigeria is considered to be a safe country, you may be detained and basically your application considered at a faster rate. So you may have your application considered while you're in detention. If you are in a family unit, you may have to be subject to further interviews. But what I'll say to you is make sure you get proper advice. It's always the same thing that we're singing. Because, yes, you may qualify for asylum. And you may be absolutely right to do so. Because your situation has changed. But again, make sure you get proper advice in before you actually present yourself to the Home Office. Make sure that you are fully aware of what is likely to happen afterwards.
Do you need legal advice? Do you need professional help at a reasonable cost? At Obaseki Solicitors we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
Briefly, quickly, what would you advise somebody who has been arrested, detained by the Home Office, and probably has stayed 3-4 years in the country, and probably has 3 or 4, 5 years old child in the UK,
Okay.
and the person is detained?
If the person is detained,
what kind of application would such a person put in?
number one, it would be very hard for you to make an application because you've been in the country for such a short period of time.
So what would you be advising the person?
I'd be advising the person to consider going home voluntarily, because if you don't, you allow the situation to control you. If you don't advise the Home Office that you actually are part of a family unit, you risk your family unit being separated. On top of that, if you are removed, you also face the period of ban before being able to come back. Whereas if you go voluntarily, you actually keep your credibility. You then are able to retain your family unit. You may also qualify for the government help. And when you go back, you may qualify to go to another country. Canada is there, America is there, New Zealand is there, Australia is there. Why would you jeopardize yourself to stay in a country that you don't qualify to remain in and put yourself at such monumental risk? Whether you are here and you're fagburin and you're managing to get some money that you're sending home, you have to outline whether that is for you, and the subject to putting yourself to that risk is for you. But you cannot put yourself forward to make an application in those circumstances, one that you will not qualify for. Unless you feel that you are at risk if you go back to your country, then you will think about making an asylum application. It's as simple as that.
All right, Jennifer, thank you so much for that clarification you've made on this program. You you can send us an email, you can contact the phone number on the screen, or you can even call Jennifer Obaseki straight. If you Google Jennifer Obaseki, office is located at Acne, or you can just call the phone number on the screen, or you can even call Bein Television, ask for Tunde Alabi, who might be able to help you or give you a better advice. Jennifer Obaseki, the solicitor in the house, might be able to help you. But we advise that keep your head down, have a low profile, and be nice and be gentle, and pray as well as you can. If you're a Christian or Muslim, and don't be involved in any trouble. Don't get involved in any trouble. If you have overstayed, you're thinking about going on voluntarily, probably want to consider that option. But better still, speak with your solicitor or legal advisor. It's been a pleasure having you on the program today, Jennifer. Thank you for coming on the show today.
My pleasure again. Thank you very much.
Until we come your way again, stay out of trouble. Bye. As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel, Bein TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you